Mr Chair,
Commencement.
I seek leave of the Committee of the House to have the officials' advice provided under the Social Security Extension of Young Person Services and Remedial Matters Amendment Bill that is related solely to the matters under consideration in the Social Security Commencement of Benefits Amendment Bill, that information be excised from the Select Committee and be provided to the Committee of the whole House.
And the member might want to add a little bit more so that members can use it for debate purposes.
So that members can use it for debate purposes?
Because otherwise I'd have to stop you.
Sure.
Right. I think that's relatively clear. Is there any objection to that material being provided?
What?
Sorry? But there is objection. There is objection, it cannot.
We're doing the law.
Chris Hipkins.
Thank you very much, Mr Chairman. And I would like to thank the Minister who was in the chair a moment ago, and Tolly, for her contribution with regard to the concerns that I was raising about what the original intent in the passage of the legislation was. And I have some further comments to make on that in response to the Minister, because she raised the issue, first of all, of what the government policy of the day was, not what the legislation was. And ultimately, the question therefore becomes, from a legal standpoint, which takes precedent, government policy or legislation? And actually, the law is pretty clear. Legislation trumps government policy. Government policy informs legislation in the way the government present it to the House, but the word of the law is what ultimately takes precedence. So regardless of what the government's policy intention was at the time, the question was what the legislative intent was at the time, and the legislation, it seems to me from a very clear reading of the Act, was actually quite clear. So then the question becomes, what remedy is there if there was an error in the Act? And so we turn to McGee, the authority on these issues in the New Zealand House, and it makes it very clear that if there is an error in the drafting of legislation, the law that takes precedence, the law that applies, is in fact the law as assented to. So even if there are mistakes between the House passing legislation and it being signed by the Sovereign, being given the royal assent, it is the legislation that receives the assent that ultimately becomes the law. So even if the government's intention wasn't enacted by the law, the fact is that was the law that was signed by the Governor-General, therefore that was the law that applied. And therefore, is there good cause for retrospectivity? And so I then turn to the Legislation Design and Advisory Committee's advice on these matters. And the Legislation Design and Advisory Committee is very clear. It's in the very beginning principles of legislative design that they specify. Legislation, part 1.7, legislation should not affect existing rights and should not criminalise or punish conduct that was not punishable at the time it was committed. And they go on further to say the presumption against retrospectivity. The general rule is that legislation should have prospective, not retrospective effect. So therefore the question that the committee needs to turn itself to is whether there is good justification for effectively taking away someone's rights, for making right something that was wrong, or wrong something that was right previously. And I think that the Parliament needs to be very, very careful in doing that, particularly when it comes to issues of individual rights and entitlements. So this is not an authority that we're dealing with, it's not a legislative body, it's not a government department so much. This is something that affects individual citizens. And I think the Parliament needs to tread very carefully when we're trying to change the law retrospectively in that regard, particularly as these retrospective changes go all the way back to 1998. So the better part of 2 decades worth of previous application of the law that are being retrospectively changed by this legislation. And I think we need to be very careful about that, because I think that the Legislation Design and Advisory Committee are quite right in their guidance to the House and to those drafting legislation that prospectivity should be the main principle behind legislative drafting, not retrospectivity. So to recap those 2 points that I just made, or 3 points that I just made, regardless of the government's policy intention at the time, it is the legislation as given the royal assent that takes precedence, that triumphs. Secondly, if there were mistakes in the legislation that was given the royal assent, it is the version of the legislation given the royal assent that ultimately is the law. And so regardless of whether the mistakes were in government policy or in the drafting of the law, once it was passed and once it was assented to by Parliament, that was the law, and that has been the law since 1998. And then the third point is there a case for retrospectivity? And really, I think that the Parliament will be going against itself and against its own advice and against its own better principles if we allow this legislation to go through with the retrospective clauses that exist within it, because we I think enter dangerous territory when we pass the legislation in the way that we are going to be passing it if this Act is passed now. So there are further points that I'm going to make about the substance of Clause 5, but I will do them in a further contribution. Thank you.